Our Heavenly Father, the fount of all goodness and grace, the cause of wisdom, the source of intelligence, we welcome you, O Lord, to this auspicious gathering of your beloved, who continuously give you thanks for every opportunity to learn something new and become fruitful to the works of your creation. We humbly come to you, not because we are worthy, but because we find ourselves in need of you, who is our strength and our hope, to continue despite the challenges we face in health, prosperity, and our solidarity with one another. We pray that today's gathering, made possible by the grace of advancements in technology and social media, becomes successful in its endeavors, so we can offer it back to you as our humble offering to honor you, glorify you, and love you through our deeper connection with everyone. May we find bliss in today's session and become more productive children and co-creators of the earth. This we ask and pray through Christ our Lord. Amen.
Good afternoon to everybody watching our stream over on Facebook Live. I'm Regina and I am your host for the Best Bar Ops lecture series titled Frequently Asked Topics on the 8 Bar Subjects. Welcome to our dear speaker, deans, professors, and bar takers tuning into our stream. Yesterday we had the PALS president, Dean Jim, give his lecture on criminal law to answer everybody's FAQs on the subject. We still have today, Friday, and Saturday for more lectures to help our dearest bar takers with exams coming around the corner. We hope that everybody taking the bar exams are staying healthy and keeping safe for this big event. The Frequently Asked Topics on the 8 Bar Subject Lecture Series is brought to you by the Philippine Association of Law Schools in collaboration with Rex Bookstore and Educampion. To know more about this month's event partner, let's all watch this video. Okay, I think we are having some technical difficulties, and we will now proceed with our program. So today's program aims to determine the most frequently asked questions on the 8 bar exam subjects and the ways to answer them, namely for legal ethics. And to answer these FAQs, we have a distinguished guest to help us. He has prepared a presentation to help the bar takers as they take the exam of their life. To introduce this afternoon's speaker, Dean Jose Aguila Grapilon received his Bachelor of Arts degree from Divine Word University as magna cum laude, and later his Bachelor of Laws degree from the University of the Philippines. He also received his Diplomat in Industrial Relations, Master in Public Administration, and Master in Industrial Relations from UP, and his Master of Laws from the Pamantasan ng Lungsod ng Maynila. He also participated in the 33rd Academy of American and Comparative International Law at the Southern Methodist University in Dallas, Texas, USA. He also participated in the Harvard University Law School program of Instruction of Lawyers in Cambridge, Massachusetts. Aside from actively practicing law, he was also an instructor in Divine Word College, a chairman of the Integrated Bar of the Philippines Bar Discipline Committee, and a certified panelist in the International Center of Arbitration, Houston, Texas, USA. He served as Deputy General Counsel of the World Jurist Association the Secretary General of Alumni Association of the Academy of American and Comparative International Law in Dallas, Texas, USA, the National President of the Integrated Bar of the Philippines, the rotating chair of the Presidents of Law Association in Asia, and the President of Law Asia Philippines. Currently, Dean Grapilon is the founding partner of Grapilon, Chan, and Pasana Law Offices, as well as his own firm, J.A. Grapilon Office. He is an international commercial arbitrator, a Supreme Court accredited senior mediator, and serves as the national president of Union International des Avocats and the national president of the Philippine Association of Law Professors. He is also the dean of the Philippine Law School, a professor at the Philippine Law School, Far Eastern University Institute of Law, and pamantasan ng lungsod ng Maynila College of Law, a mandatory continuing legal education lecturer, and the Senior Bar Discipline Commissioner. Without further ado, let's all welcome this afternoon's lecturer, Dean Jose Aguila Grapilon.
Thank you very much, Regina. I think what I will be saying here will be all known to those who are viewing us and those who are participating in this lecture. But I'll start by reminding you again of the Supreme Court syllabus on legal ethics for these bar exams. Number one, you will have noticed that it involves qualifications for new lawyers, including those who reacquire citizenship. Number two, the Code of Professional Responsibility, including duties incorporated in the lawyer's oath. Number three, the disqualification and inhibition for judges. And I will include here a discussion on the new Code of Judicial Conduct. And the fourth is on direct and indirect contempt. On the last topic, I have gathered from and gleaned from the ponencia of former Chief Justice Bersamin on direct and indirect contempt, where he expounded so elaborately on these particular topics. Some wicked, perhaps your wicked examiner in the coming weeks may ask you to write down, thinking that you have memorized already the lawyer's oath. And may I read it again? The lawyer's oath as basis for the duty of the lawyer to uphold the Constitution, laws, and rule of law. It says here that I do solemnly swear that I will maintain allegiance to the Republic of the Philippines. I will support its constitution and obey the laws as well as the legal orders of the duly constituted authorities therein. I will do no falsehood nor consent to doing the same of any in court, and I will not wittingly or unwittingly, nor will promote or pursue any groundless, false, or unlawful suit, or give aid or consent to the same. I will delay no man for money or malice, and will conduct myself as a lawyer according to the best of my knowledge and discretion, with all the good fidelity as well as to the court, as to my clients. I impose upon myself this voluntary obligation without any mental reservation or purpose of evasion, so help me God. I don't know if the Supreme Court right now will accept affirmation and not an oath in the lawyer's oath. And I think those who have other religious affiliations may request the Supreme Court that they don't have to take the oath, but just to affirm the duties of a lawyer and the concomitant obligations of the lawyer himself. The lawyer's oath would include, of course, the duties of attorneys under Section 138, Section 1220 of Rule 138, where it is said that unenumerated, number one, must, of course, maintain allegiance to the Republic of the Philippines and to support the Constitution. The second is to observe and maintain the respect due to the courts of justice and judicial officers. The third is to counsel or maintain the respect due to the courts of justice and judicial officers. The third is to counsel to maintain such actions or proceedings only as appear to him to be just, and such defenses only as he believes to be honestly debatable under the law. The fourth is to employ for the purpose of maintaining the causes confided to him such means only as are consistent with truth and honor, and never seek to mislead the judge or any judicial officer by an artifice or false statement or fact of law. The fifth is to maintain, inviolate the confidence and at every peril to himself to preserve the secrets of his clients and to accept no compensation in connection with his client's business, except from him or with his knowledge and approval. And the next is to abstain from any offensive personality and to advance no fact prejudicial to the honor or reputation of a party or witness unless required by the justice or the cause which he is charged. The next is to not to encourage either the commencement or continuance of an action or proceeding or delay any man's cause from any corrupt motive or interest. The second to the last is never to reject, for any consideration personal to himself, the cause of the defenseless or oppressed. And the last is, in the defense of the person accused of crime, by all fair and honorable means, regardless of his personal opinion as to the guilt of the accused, to present every defense that the law permits to the end that no person may be deprived of life, liberty, but only by due process of law. We will be discussing this extensively in the next 2 hours or so. And I know that most of you already are know what I will be speaking, but I really would have wished to have shared some of the PowerPoint presentations here, but this is culled actually from a copyrighted article which I jointly shared with one other lawyer, and according to him, he will be requesting its publication in the coming months. So I'm sorry I cannot share with you some of what he has done and the product of his efforts. But in any case, I got the permission from him that if I may at least get snippets of what he has written, it will help very much in the lecture this afternoon towards the evening. So we start with the requirements before admission to the bar and for continuous practice of law, etc. You have already the court ruling in No Laksaman versus Attorney Busmente in 2011, which said, with reference to the practice of law, that the court here ruled that the term practice of law implies customarily or habitually holding oneself out to the public as a lawyer for compensation or as a source of livelihood or in consideration of his services. The court further ruled here that holding oneself out as a lawyer may be shown by acts indicative of the purpose, such as, this one is underlined, the phrases are underlined, identifying oneself as attorney, appearing in court in representation of a client, or associating oneself as a partner of a law office for the general practice of law. In fact, under the new rules on evidence, there are exceptions to the hearsay rule, which exonerates somehow the client when he believes that the person, having represented himself as a lawyer when he is not, can consider that particular representation as hearsay evidence. Any activity in and out of court that requires the application of law, legal procedure, knowledge, training, and experience. Moreover, in the case of the inquiry of Attorney Severi Bofi, the court ruled here and explained that in the practice of law, it is to perform those acts which are characteristics of the profession. In practice, it is said that it is to give notice or to render any legal advice and service and requires the use in any degree of legal knowledge or skill. The last phrase is underlined. The practice of law is not limited to the conduct of cases or litigation in court. It embraces the preparation of pleadings and other papers, incident to actions and special proceedings, the management of such actions and proceedings on behalf of clients for judges and courts, and in addition, it may include conveyancing. I think you all remember and recall the case of Attorney Christian Mulsod, and therein it was defined what is the practice of law, which enabled, of course, Attorney Christian Mulsod to be considered still as in the practice of law, even as in that case he has not appeared at least once in court of law. In general, in Aguirre versus Rana, all advice to clients, all actions taken for them in matters connected with the law constitutes the practice of law. Section 1 of Rule 138 of the Rules of Court provides on those who may practice law, and I quote, any person heretofore duly admitted as a member of the bar or thereafter admitted as such in accordance with the provisions of this rule and who is in good and regular standing is entitled to practice law. We find no alternative than to separate him from the service with the admonition that he should desist from appearing in any court or investigative body wherein only members of the bar are allowed to practice. That was the gist of the Supreme Court ruling in Zeta versus Malinaw. You will find all these citations in several books on legal ethics, but what I did and wanted to convey to you was these salient examples of who may practice law. A bar candidate does not acquire the right to practice law simply by passing the bar. The practice of law is privilege that can be withheld even from one who has already passed the bar examinations if the person seeking admission to the bar had practiced law without a license. It is true in the case of still Aguirre versus Rana that the respondent has passed the 2000 bar examinations and took the lawyer's oath. However, in double emphasis, it is the signing in the roll of attorneys that finally makes one a full-fledged lawyer. The fact that respondent passed the bar examinations is certainly immaterial. Passing the bar is not the only qualification to become an attorney at law. Respondent should know that two essential requisites for becoming a lawyer still had to be performed, namely, the lawyer's oath to be administered by this court and his signature in the roll of attorneys. In the case of Attorney Elmo Abad, respondent Abad should know that the circumstances which he has narrated do not constitute his admission to the Philippine bar and the right to practice law thereafter. He should know that two essential requisites for becoming a lawyer still has to be performed, again, doubly emphasizing his lawyer's oath to be administered by the court and his signature in the roll of attorneys. The case of whether or not a lawyer is entitled to exemption from payment of his IBP dues during the time that he was inactive in the practice of law has been answered in this wise. Thus, payment of dues is a necessary consequence of membership in the IBP, of which no one is exempt. Remember that the Integrated Bar of the Philippines was sanctioned by law in 1973 through the Herculean efforts of no less led by the late Justice J.B.L. Reyes. And from then on, from 1973, this has been the mandatory compulsory organization of lawyers in the country. This means that the compulsory nature of payment of dues subsists For as long as one's membership in the IBP remains regardless of the lack of practice or the type of practice the member is engaged in. There is nothing in the law or rules which allows exemption from the payment of membership dues. In the letter of Attorney Cecilio V. Arevalo Jr., the Supreme Court said that at most, as correctly observed by the IBP, he could have informed the Secretary of the Integrated Bar of his intention to stay abroad before he left. In such case, his membership in the IBP could have been terminated and his obligation to pay dues could have been discontinued. There are so many cases like this in not only the United States but in other foreign countries where there's those who have passed the Philippine bar examinations are based abroad and sometimes even together with some retired justices of the Court of Appeals, we conduct mandatory continuing legal education in these areas. And the continued membership of these lawyers who are based in the US, for example, and Europe, is based on the fact that they still retain membership by paying their dues in the IBP. A membership fee in the Bar Association is an exaction for regulation. And while as distinguished from a tax, the tax purpose is for revenue. If the judiciary has inherent power to regulate the bar, it allows that as an incident to regulation, it may impose a membership fee for that purpose. It means it would not be possible, to put an integrated bar program without means to defray its expenses. The doctrine of implied powers necessarily carries with it to impose such an exaction. Under Canon number 9, referring to whether there is a provision under the Code of Professional Responsibility which prohibits the unauthorized practice of law, Canon number 9 says that a lawyer shall not directly or indirectly assist in the unauthorized practice of law. While the reading of Canon 9 appears to merely prohibit lawyers from assisting in the unauthorized practice of law, the unauthorized practice of law is, by the lawyer himself, is subsumed under this provision, which means that because the heart of Canon 9 is the lawyer's duty to prevent the unauthorized practice of law, therefore he's covered within this particular purview. What may be examples of unauthorized practice of law? You may have cases where we found the party liable for the unauthorized practice of law. The party was guilty of some overt acts like, number 1, where the party signs court pleadings on behalf of his client. Number 2, appearing before court hearings as an attorney. Number 3, manifesting before the court that they will practice law despite being previously denied admission to the bar. Or number 4, deliberately attempting to practice law. Or number 5, knowledge, out himself as a lawyer through circulars with full knowledge that he is not licensed to do so. Section 6 of Rule 138 on pre-law requirements says that no applicant for admission to the bar examination shall be admitted unless he presents a certificate that he has satisfied before the Legal Education Board, before he began the study of law, he has pursued and satisfactorily completed in an authorized and recognized university or college, requiring for admission thereto completion of a 4-year high school course in the course of study prescribed therein for a bachelor's degree in the arts and sciences with any of the following subjects as major or field of concentration. You have political science, logic, English, Spanish, history, and economics. The case of Amy Marcos is a particular example where she was not allowed to even apply to bar examinations because she enrolled at the University of the Philippines College of Law, and when time came for her and her classmates to applied to take the bar examination. It was found out that she was not a graduate of a 4-year course, and her allegations that she was a graduate of Princeton was not substantially or sufficiently proven. So much so that Amy Marcos uh, did not pursue her dream of becoming a lawyer and member of the Philippine Bar. A violation of this under Section 6 of Rule 138, utilizing the records of his cousin and namesake, in actual fact, petitioner having not completed grade 6 of his elementary schooling, much less first and second year high school, making it appear that he had finished or completed grade 6 elementary and first and second year high school, when in truth and in fact he had not, violates the provisions of Section 5 and 6, Rule 127 of the court, which requires completion by a bar examiner candidate of the prescribed courses in elementary, pre-law, high school prior to his admission to the practice of law. This is a clever way of, applying for the bar. I don't know if Publico, in his petition, if he were allowed to take the bar, would have passed it anyway. But the grit and the daring by which Mr. Publico has would even entitle me to commend him for such valiant try, though marred by deceit and bad faith. Is breach of promise to marry, for example, one of those which is considered as gross immorality, which will make the lawyer liable for disciplinary action. In the case of Figueroa versus Barranco Jr., the respondent was prevented from taking the lawyer's oath in 1971. That was the year I took the bar exam, because the charge of gross immorality made by complainant. In this case, respondent bore an illegitimate child with his sweetheart, Patricia Figueroa, who also claims that he did not fulfill his promise to marry her after he passes the bar examinations. The court said that the facts do not constitute gross immorality, warranting the permanent exclusion of respondent from the legal profession. The court doubly emphasized and said that disengaging in premarital sexual relations with complainant and promises to marry suggests a doubtful, at the maximum, moral character on his part, but the same does not constitute grossly immoral conduct. The court has held that to justify suspension or disbarment, the act complained of must not only be immoral, but grossly immoral. A grossly immoral act is one that is so corrupt and false as to constitute a criminal act, or so unprincipled or disgraceful as to be reprehensible to a high degree. It is a willful, flagrant, or shameless act which shows a moral indifference to the opinion of respectable members of the community. How do you now compare good moral character with rehabilitation in order that the person who is applying to be certified as the member of the bar would do? When an applicant for admission to the bar has committed first-degree murder, a crime that demonstrates an extreme lack of good moral character, he must make an extraordinary showing of present good moral character to establish that he or she is qualified to the practice, admitted to the practice of law. To show rehabilitation, one must show that he has accepted responsibility for his criminal act. Rehabilitation is a necessary but not sufficient ingredient of good moral character. And one who has been convicted of a serious felony, the applicant must establish his current good moral character independent of and in addition to evidence of rehabilitation. Rehabilitation is not enough, and even assuming that one has established rehabilitation showing rehabilitation from criminal conduct does not in itself establish good moral character. Rehabilitation is a necessary but not sufficient ingredient of good moral character. An applicant must establish his current good moral character independent of or in addition to evidence of rehabilitation. Even assuming that he has established rehabilitation, showing rehabilitation from criminal conduct does not in itself establish good moral character. What then is considered as an upright character? It is something more than an absence of bad character. It means that he, the applicant or she, must have conducted himself as a person of upright character ordinarily would, should, or does. Such character expresses itself not in negatives, nor in following the line of least resistance, but quite often in the will to do the unpleasant thing if it is right and the resolve not to do the pleasant thing if it is wrong. Under the rule applicable to a particular case, our concern must be with the applicant's present moral character. The commentator Greenberg and the court quoted him in saying that it is the applicant's moral character as of now which we are concerned. Past misconduct, however, is not irrelevant, though. Rather, this court must determine what past bad acts reveal about an applicant's current character. Although a prior conviction is not conclusive of a lack of present good moral character, it adds to his burden of establishing present good character by requiring convincing proof of his full and complete rehabilitation. Is poverty of litigant a justification to engage in illegal practice of law? The defense in one case, the defense of respondent says that his participation for defendant's cause was gratuitous as they could not engage the services of counsel by reason of poverty and the absence of one in the locality cannot, even if true, carry the participation of the lawyer as legal, and this lawyer should be sanctioned. As a matter of law, can a lawyer detainee practice law? When a person indicted for an offense is arrested, he is deemed in place under the custody of the law. He is placed in actual restraint of liberty so that he may be bound to answer for the commission of the offense. He must be detained in jail during the pendency of the case where bail is not available unless he is authorized by the court to be freed based on, as I said, bail or recognizance. It must be stressed that all prisoners, whether under preventive detention or serving final sentence, cannot practice their profession nor engage in any business or occupation to hold public office, elective or appointed, while in detention. This is a necessary consequence of arrest and detention. In Santos Jr. versus Attorney Llamas, under Rule 139-A, Section 10, which provides that default in the payment of annual dues for 6 months shall warrant suspension of membership in the integrated bar, and default in such payment for 1 year shall be ground for the removal of the name of the delinquent member from the roll of attorneys. Time and time again, you read that you sometimes are apprised of the fact that the Supreme Court memoranda on non-payment of dues will result in the lawyer being deleted from the roll of attorneys. The lawyer must indicate his proper IBP chapter and receipt number by indicating, for example, that the lawyer has IBP Rizal 25060 in his pleadings, and thereby misrepresenting to the public and the courts that he has paid his IBP dues, respondent is guilty of violating the Code of Professional Responsibility, which provides that under Canon 7, a lawyer shall at all times uphold the integrity and dignity of the legal profession and support the activities of the integrated bar. Under Canon 10, likewise, lawyer owes candor, fairness, and good faith to the court. It is subsumed under Rule 10.1, which says that the lawyer shall not do any falsehood nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. The question is very interesting. Is a senior citizen lawyer exempted from payment of ITR also exempt from the payment of IBP dues? Still, in the case of Attorney Llamas, while it is true that the Republic Act 7432 grants senior citizens exemption from the payment of individual income taxes, provided that their annual taxable income does not exceed the poverty level as determined by the NEDA, the exemption does not include payment of membership or association dues. Intent is necessary to be guilty of unauthorized practice of law. In several cases, the court has ruled that the unauthorized practice of law, by assuming to be an attorney and acting as such without authority, constitutes indirect contempt, which is punishable by fine or imprisonment or both. The liability for the unauthorized practice of law under Section 3, Rule 71 of the Rules of Court, is in the nature of a criminal contempt, and the acts are punished because they are an affront to the dignity and authority of the court and obstruct the orderly administration of justice. And in determining liability for criminal contempt, well settled is the rule that intent is a necessary element and no one can be punished unless the evidence makes it clear that he intended to commit it, the usual mens rea thing. Thus, giving up Philippine citizenship automatically result into loss or membership in the Philippine Bar, in answer to the Supreme Court's syllabus on legal ethics, which should include those who reacquire citizenship. The Constitution provides that the practice of all professions in the Philippines shall be limited to Filipino citizens, save in cases prescribed by law. Since Filipino citizenship is a requirement for admission to the bar, laws thereof terminates membership in the Philippine Bar, and consequently, the privilege to engage in the practice of law. In other words, the laws of Filipino citizenship ipso iure terminates the privilege to practice law in the Philippines. The practice of law is a privilege denied to foreigners. This is in the case of petition for leave to resume practice of law by Attorney Dacanay, bar matter. It's a bar matter. But recent developments in the globalized law practice points to the fact that somehow I would like to think that our Supreme Court will not as if to relax the rule, but to liberalize, for example, the contextual aspect of the practice of law in the country, where, for example, a New Zealander, a lawyer from New Zealand may be allowed to advise lawyers in the Philippines on a particular case which involves, for example, knowledge and application of New Zealand law and all other laws of different nationalities, nations for that matter. May a lawyer who lost his Filipino citizenship still practice law in the Philippines? The Constitution again provides that the practice of all professions in the Philippines shall be limited to Filipino citizens. And since Filipino citizenship is a requirement for admission to the bar, laws thereof terminates membership in the Philippine Bar and consequently the privilege to engage in the practice of law. In other words, the laws of Filipino citizenship will terminate the privilege to practice law in the Philippines. A Filipino lawyer who becomes a citizen of another country and later reacquires Philippine citizenship under Republic Act number 9225 remains to be a member of the Philippine Bar. Requirements needed before one can resume practice of law after reacquiring Philippine citizenship. Before a lawyer who reacquires Filipino citizenship pursuant to the dual citizenship law can resume his law practice, he must first secure from the court the authority to do so conditioned on, number one, the updating and payment in full of the annual membership dues to the IBP. Number two, the payment of professional tax. Number three, the completion of at least 36 hours of mandatory continuing legal education, especially significant to refresh the applicant petitioner in the knowledge and development of Philippine laws and to update him of these legal aspects. Number four is the retaking of the lawyer's oath, which will only remind him of his duties and responsibilities as a lawyer and as an officer of the court, but also renew his pledge to maintain allegiance to the Republic of the Philippines. The retaking of the lawyer's oath, which will not only remind him of his duties and responsibilities as a lawyer and as an officer of the court, but also renew his pledge to maintain allegiance to the Republic of the Philippines. The practice of all professions in the country according to the Constitution, Section 14, Article 12, shall be limited to Filipino citizens save in cases prescribed by law. Any provision of law to the contrary notwithstanding, natural-born citizens of the Philippines by reason of their naturalization as citizens of a foreign country are hereby deemed to have reacquired Philippine citizenship upon taking the oath of allegiance. Natural-born citizens of the Philippines who, after the effectivity of Republic Act on dual citizenship, become citizens of the foreign country and shall retain Philippine citizenship on taking the particular oath. Requirements for applicants to admit, for all applicants for admission to the bar includes, among others, that the applicant for admission as a member of the bar must be a citizen of the Philippines at least 21 years, of good moral character, and a resident of the Philippines, and must produce before the Supreme Court satisfactory evidence of good moral character and no charges against him involving moral turpitude have been filed or pending in court. And since the controversy right now rests on what is the meaning of moral turpitude, may we remind again our future lawyers and lawyers for that matter of what is the meaning of moral turpitude. May I quote by saying that conviction in Nunez versus Astorga, the conviction of a crime involving moral turpitude, a lawyer is deemed to have become unfit to uphold the administration of justice and to be no longer possessed of good moral character. And the court continues to define the meaning of moral turpitude as everything which is done contrary to justice, modesty, or good morals. It is, in the case of Basa, an act of baseness, vileness, or depravity in the private and social duties which a man owes his fellow men or to society in general, contrary to justice, honesty, modesty, or good morals, which I think would require a lot more elaboration and explanation. And I would like to believe, and I would have thought that there will be specific definitive examples of this, but certainly you will have noticed that cases involving moral turpitude will depend precisely on several factors and circumstances, which makes it falls under the category of moral turpitude. The Bongbong controversy involves what they say disqualification or cancellation of this certificate of candidacy because of a crime, a conviction of a crime involving moral turpitude, which is not yet decided. The second requirement for the practice of law is membership in good standing. It is a continuing requisite. This means continued membership and concomitantly the payment of annual membership dues to the IBP, payment of the professional tax, compliance with the MCLE program, faithful observance of the rules and ethics of the legal profession, being continually subject to judicial disciplinary control. Admission to the bar involves various phases, such as furnishing satisfactory proof of educational, moral, or other qualifications, passing the bar examinations, taking the lawyer's oath and signing the roll of attorneys, and receiving from the clerk of court a certificate of the license to practice law. What is a lawyer's proof of authority to practice law? Under Rule 138, Section 18, the Supreme Court shall thereupon admit an applicant as a member of the bar for all the courts of the Philippines, and shall direct an order to be entered to that effect upon the records, and that the certificate of such record shall be given to him by the clerk of court, which certificate shall be his authority to practice. If the petitioner did not sign the roll of attorneys, for example, for 32 years, what he has signed at the entrance of the PCC was probably just an attendance record. This is therefore how we see fit to impose upon him a penalty akin to suspension by allowing him to sign in the roll of attorneys 1 year after the receipt of the resolution. For Attorney Midado, transgressing the prohibition against an authorized practice of law, he was fined the amount of 20,000 pesos. The Integrated Bar of the Philippines also gives a certificate of membership in good standing, and this means that if it is given by a particular chapter of the Integrated Bar, it does not necessarily constitute his admission to the Philippine Bar and the right to practice law thereafter. Questions of certification and authentication, for that matter. So you have authority of an attorney to appear in behalf of a client under Section 21. An attorney is presumed to be properly authorized to represent any cause in which he appears, and no written power of attorney is required to authorize him to appear in court for his client. But the presiding judge may, on motion of either party and on reasonable grounds thereafter being shown, require any attorney who assumes the right to appear in case to produce or prove the authority under which it appears, and to disclose whenever pertinent to any issue the name of the person who employed him, and may thereupon make such order as justice requires. Usually what they do is just the verification phase where the client himself or herself will sign, and that constitutes the authority of the lawyer to represent the client in his or her behalf. An attorney willfully appearing in court for a person without being employed unless by leave of court may be punished for contempt as an officer of the court who has misbehaved in his official transactions. The title of attorney is reserved to those who, having obtained the necessary degree in the study of law and successfully taken the bar examinations, have been admitted to the Integrated Bar of the Philippines and remains members thereof in good standing, and it is they only who are authorized to practice law in our jurisdiction. His disinclination in the case of Alawi versus Alaoyan to use the title of counselor does not warrant his use of the title of attorney. What are the prohibited acts, for example, of examinees? No candidate shall endeavor to influence any member of the committee of the bar examiners, and during examination the candidate shall not communicate with each other, nor shall they give or receive any assistance. The candidate who violates this provision shall be barred from the examination, the same to count as a failure against him, and further disciplinary action, including permanent disqualification, may be taken in the discretion of the court. I can rightfully guess that there will be a lot of challenges in the coming bar examinations because of the situation and the circumstances under which these bar examinations become so special. in the context of the present times. Attorney Alan Pagia was a very controversial but colorful figure. His flamboyance somehow landed him the ire of some people, including the Supreme Court's suspending him for particular acts which violated the Code of Professional Conduct. In the case of Attorney Pagia, the question was, can an indefinite suspension from the practice of law prohibit him from filing a citizen or taxpayer suit? Who is this guy right now who has been indefinitely suspended and who is running for a senatorial position? And I think it will be difficult later on to justify in case still commits several acts which are not only inimical to the legal profession but also outright violations, blatant violations of the Code of Professional Conduct. In the case of Attorney Pagia, he maintained that as a citizen and taxpayer, he can file the original action for the writ of certiorari to invalidate President Gloria Macapagal Arroyo's nomination of respondent former Chief Justice Hilario Davide Jr. as permanent representative to the United Nations for violation of the Philippine Foreign Service Act of 1991. In their separate comments, Respondent Davide, the Office of the President and the Secretary of Foreign Affairs, raised threshold issues against the petition. First, they questioned petitioners' standing to bring this suit because of his indefinite suspension from the practice of law. An incapacity to bring legal actions peculiar to petitioner also obtains, and in this case, petitioner's suspension from the practice of law bars him from performing, quote unquote, any activity in our court of law which requires the application of legal procedure, which requires knowledge, training, and experience in the legal field. Certainly, preparing a petition raising carefully crafted arguments on equal protection grounds and employing highly legalistic rules of statutory construction to par Section 23 of Republic Act 7157 falls within the prescribed conduct. Interpretation, clarification, implementation of Rule 138 of the Rules of Court governing law student practice and Rule 138A of the Rules of Court in case of Cruz versus Mina answers the basic question of whether a law student may appear before an inferior court as an agent or friend of a party litigant. Those are taking the bar. No, for example, the program of the Supreme Court of clerk, and this somehow in a modified manner changes some of the aspects of the original student practice rule. So, pro se, for example, the complaint is irregular as it is signed by the plaintiff by one who is not a member of the bar and who designated himself as friend counsel of the plaintiff. Section 3, Rule 7 says that every pleading must be signed by the party or counsel representing him, stating in either case his address which should not be a post office box. An unsigned pleading produces no legal effect. Under the facts of this case, the applicable provision is Section 34, Rule 138 of the Rules of Court. And the rules are clear, for example, in municipal courts, where the litigant may be assisted by a friend, agent, or an attorney. However, in cases before the regional trial court, the RTC, where the litigant must be aided by a duly authorized member of the bar, the rule invoked by the Torsinos, who are defendants in this case, applies only to cases filed with the regional trial court and not to cases before municipal trial court. Requirements before admission to the bar and for continuous practice of law would involve, for example, other aspects on who may practice of law, who can appear in court or investigative body. We find no alternative in the case, for example, of Seta versus Manila, that he should desist from appearing in any court or investigative body where only members of the bar are allowed to practice. So we move to another module, and we move to the attorney's fees and compensation for legal services. Canon 20 of the Code of Professional Responsibility talks about a lawyer shall charge only fair and reasonable fees. Rule 20 says that the lawyer shall be guided by the following factors in determining his fees: the time spent and the extent of the service rendered or required, the novelty and difficulty of the questions involved, the importance of the subject matter, the skill demanded, and the probability of losing other employment as a result of acceptance of the preferred cases. With that, for example, the customary charges for similar services and the schedule of fees of the IBP chapter to which they belong. Palagay ko, i-mute nyo, people. The contingency of the compensation, excuse me, Regina, some guys may not be muting. The amount involved in the controversy and the benefits resulting. Ayos. Regina, would you kindly tell these guys to mute?
Yes, perfect.
Oh, no, I saw it. The contingency or certainty of compensation, the character of the employment, hindi nag-mute.
Sorry, we'll get it up.
I will just wait.
Miss Carla? Miss Carla?
But some are not observing etiquette anyway. Anyway, we're talking about lawyers charging only fair and reasonable fees, and if I may recapitulate, it involves also the customary charges for similar services, and the schedule of fees of the IBP chapter to which it belongs, which includes, among others, also factors for the professional standing of the lawyer, which is quite important because some clients may not understand the fact that some senior lawyers, some lawyers of professional standing would not be comparable to fledgling lawyers or those who are junior lawyers who would charge lower fees than senior lawyers for that matter. And this becomes actually not really an irritant, but in several chapters in the Integrated Bar of the Philippines, has been the usual dialogue with the defense of the bar whenever it convenes to discuss matters involved in chapter jurisdictions. A lawyer shall, in case of referral, with the consent of the client, is entitled to a division of fees in proportion to the work performed and responsibility assumed. In Rule 20, it also includes a lawyer shall not, without the full knowledge and consent of the client, accept any fee, reward, costs, commission, interest, rebate, or forwarding allowance or other compensation whatsoever related to the professional employment from anyone other than the client. Rule 20 also says that the lawyer shall avoid controversies with clients concerning his compensation and shall resort to judicial action only to prevent imposition, injustice, or fraud. The basis for just compensation for lawyers is because his capital consists of his brains, and with his skill, he acquired at tremendous cost, not only in money but in expenditure of time and energy. He is thus entitled to the protection of any judicial tribunal against any attempt on the part of his client to escape payment of his just compensation. What is the difference now between fee and lien when you talk about lawyer compensation? These are two different matters. It is axiomatic, of course, that the lawyer must show that he or she will become entitled to a fee before he's entitled to a lien. And upon taking his lawyer's oath as an officer of the court, a lawyer submits himself to the authority of the courts to regulate his right to charge professional fees. It follows that the lawyer's compensation for professional services rendered is subject to the supervision of the court, not just to guarantee that the fees he charges and receives remains reasonable and commensurate with the services rendered, but also to maintain the dignity and integrity of the legal profession to which they belong. Apologies are I think, in order when some of the Supreme Court rulings and some of the what we are discussing here refers only when we quote on the he issue, the gender issue. But I said apologies are in order because it should be like no gender bias this particular, even in grammar or in syntax. The Code of Professional Liability Responsibility all advises lawyers to avoid controversies with clients concerning their compensation and to resort to judicial action only to prevent, again, imposition, fraud, or injustice. Suits to collect fees shall be avoided and should be filed only when circumstances force lawyers to resort to it. Under Rule 138, we have already enumerated the factors for which just compensation for lawyers are given, and the Section 25 of the same Rule 138 talks about when an attorney unjustly retains in his hands money of his client after it has been demanded, he may be punished for contempt as an officer of the court who has misbehaved in his official transactions, but proceedings under this section shall not be a bar to another independent criminal prosecution. Rule 9.02 of the same 138 talks about a lawyer shall not divide or stipulate to divide a fee for legal services with persons not licensed to practice law. And these are the instances where, for example, there is a pre-existing agreement, exemptions with a partner or associate that upon the latter's death, money shall be paid over a reasonable period of time to his estate or person specified in the agreement, or as an exception where a lawyer undertakes to complete unfinished legal business of a deceased lawyer, or where a lawyer or law firm includes non-lawyer employees in a retirement plan, even if the plan is based in whole or in part in a profit-sharing agreement. This is one of the more important things which I think even the integrated bar in my time failed to address successfully. We tried, but it was really difficult for us to impose this particular canon, which actually is a violation of the canon if it is not complied with. This rule says under Canon 16 that a lawyer shall not hold in trust all monies and properties of his client that may come into his possession. A lawyer in other jurisdictions, this is a very delicate matter, and most of the disciplinary actions in other jurisdictions emanate from this particular violation. A lawyer shall account for all money or property collected or received for or from the client. Rule 16.02 says that the lawyer shall keep the funds of each client separate and apart from his own and those of others kept by him. And Rule 16.03 says that the lawyer shall deliver the funds and property of his client when due or upon demand. However, he shall have a lien over the funds and may apply so much thereof as may be necessary to satisfy his lawful fees and disbursements, giving notice promptly thereafter to his client. He shall also have a lien to the same extent as in all judgment and executions he has secured for his client as provided for in the rules of court. This one is quite self-abnegation on the part of the lawyers, but it is, to my mind, very embarrassing. A lawyer shall not borrow money from his clients unless the client's interests are fully protected by the nature of the case or by independent advice. Neither shall a lawyer lend money to a client except when in the interest of justice he has to advance necessary expenses in the legal matter he is handling for the client. This rule is intended to prevent the lawyer from taking advantage of his influence over his client. Non-payment of a loan is violative of the professional code of responsibility, not misappropriation or embezzlement. In the case here, we find that respondent's liabilities does not misappropriation or embezzlement, but for violation of Rule 1604 of the Code of Professional Responsibility, which forbids lawyers from borrowing money from their clients unless the latter's interests are protected by the nature of the case or by independent advice. In this case, respondent's liability is compounded by the fact that not only did he not give any security for the payment of the amount known to him, but that he has also refused to pay the same amount. His claim that he could not pay the loan because of circumstances did not allow the same, and that because of the passage of time that he somehow forgot his obligation, only underscores his blatant disregard of his obligation, which reflects on his honesty and candor. A practicing lawyer in one case entered into a written agreement with the private respondents to appear as counsel in a petition for probate of the holographic will. Under the will, a piece of real property at Sales Street, Quiapo, Manila was bequeathed to private respondent. It was agreed that the attorney's contingent fee would be 35% of the property that private respondent may receive upon the probate of the will. The payment of his fees is contingent and dependent upon the successful probate of the holographic will. Since the petition for probate was dismissed by the lower court, the contingency did not occur, and the lawyer is not entitled to his fees. Obviously, it appears from the record in another case that the respondent, by means of a written contract, retained the petitioner, a lawyer here, to represent him as their lawyer. The contract fixed the petitioner's fee at 2,000 pesos in advance for the additional fee of another 11,300 pesos. It was also provided that the contract that respondent should not compromise the claim against the defendant without express consent of the lawyer. Through the sole effort of respondents, the case was dismissed without notice to their counsel. The client has also an undoubted right to compromise a suit without the intervention of a lawyer. Though there is a valid agreement for the payment to the attorney of a large proportion of the sum recovered in case of success, this does not give the attorney such an interest in the cause of the action that it prevents the client from compromising the suit. We have recently held, according to the Supreme Court, that the client has always the right to settle his cause of action and stop litigation in any stage of the proceedings, subject, however, to the right of the lawyer to receive compensation for services rendered. The principle of quantum meruit, as much as the lawyer deserves, may be a basis for determining the reasonable amount of attorney's fees. Quantum meruit is a device to prevent undue enrichment based on the equitable postulate that it is unjust for a person to retain benefit without paying for it. It is applicable even if there was a formal written contract for attorney's fees, as long as the agreed fee was found by the court to be unconscionable. The recovery of attorney's fees on the basis of quantum meruit is permitted, as in the case where there is no express agreement for the payment of attorney's fees. Basically, it is a legal mechanism which prevents an unscrupulous client from running away with the fruits of the legal service counsel without paying for it. The same, it avoids unjust enrichment on the part of the lawyer himself. When is quantum meruit authorized? In the payment of lawyer services. Examples will be where there is no express contract for payment of attorney's fees agreed upon between the lawyer and the client. Number two, when although there is a formal contract for attorney's fees, the fees stipulated are found unconscionable or unreasonable by the court. And the third is when the contract for attorney's fees is void due to purely formal defects of execution. The fourth is when the counsel, for justifiable cause, was not able to finish the case to its conclusion, and when the lawyer and client disregard the contract for attorney's fees. In fixing a reasonable compensation for the services of lawyer on the basis of quantum meruit, the elements to be considered are generally the importance of the case, the extent of the services rendered, the professional standing of the lawyer. These factors would indispensably require nothing less than a full-blown trial where private respondents can adduce evidence to establish the right to lawful attorney's fees and for petitioner to oppose or refuse the same, or refute. The trial court as the principal task of fixing the amount of attorney's fees. Therefore, the necessity of a hearing is beyond cabinet. What are tempestuous contracts on all commissions or attorney's fees that we shall receive from our clients by virtue of the collection that we shall be able to collect on their behalf? We shall divide 50-50, as an example. Likewise, you are entitled to the commission 50-50 from domestic, inheritance, commercial, from our said clients or in any criminal cases where they are involved. In the case of Dantec Bong versus David, the court ruled that said agreement is void because it was tantamount to malpractice, which is the practice of soliciting cases at law for the purpose of gain, either personally or through paid agents or brokers. Malpractice ordinarily refers to any malfeasance or dereliction of duty committed by a lawyer. Section 27 of the Code of Professional Responsibility gives a special and technical meaning to the term malpractice. An agreement whereby an attorney agrees to pay expenses of proceedings to enforce the client's right is champertus. Such agreements are against public policy, especially whereas in this case, the attorney has agreed to carry on the case at his own expense in consideration of some bargain of part between dispute. The execution of this contract violates the fiduciary relationship between the lawyer and the client, for which the former must incur administrative sanctions. As long as litigation and access to the courts remain expensive, then anyone who has the right that stands in need of vindication should be able to obtain funding from anyone willing to offer it on whatever terms it is offered. When a client employs the services of a law firm, he does not employ the services of the lawyer who is assigned to personally handle the case. Rather, he employs the entire law firm. In the event that the counsel appearing for the client resigns, the firm is bound to provide a replacement. A charging lien to be enforceable as security for the payment of attorney's fees requires as a condition sine qua non a judgment for money and execution in pursuance of such judgment executed in the main action by the attorney in favor of his client. Charging lien presupposes that the attorney has secured a favorable money judgment for his client. You have in the cases again where we have noted that the services rendered were only administrative in nature, but this does not alter the application of the proper rule, which is professional services to prepare and advocate just claims for compensation are as legitimate as services rendered in court in arguing a case to convince the court or in the case of other jurisdictions, the jury, that the claim presented or the defense set up against the claim presented by the other party ought to be allowed or rejected. Parties in such cases require advocates, and the legal profession must have a right to accept such employment and to receive compensation for the services. Is there a need for a written contract to prove lawyer-client relationship? In D versus Court of Appeals, August 24, 1989, the court ruled that the absence of a written contract will not preclude the finding that there was a professional relationship which merits attorney's fees for professional services rendered. Documentary formalism is not an essential element in the employment of an attorney. The contract may be expressed or implied. To establish the relation, it is sufficient that the advice and assistance of a lawyer is sought and received in any matter pertinent to his profession. An acceptance of the relation is implied on the part of the attorney from his acting on behalf of his client in pursuance of a request from the latter. A lawyer, again, may enforce his right to his fees by filing the necessary petition as an incident to the main action in which services were rendered, or it may be in an independent action against his client. Of course, it's preferable to utilize the former to avoid, as usual, multiplicity of suit. The Code of Professional Responsibility advises lawyers to avoid controversies with clients concerning their compensation and to resort only to judicial action, again, to prevent imposition, injustice, or fraud. What are the two commonly accepted concepts of attorney's fees? In its ordinary concept, an attorney's fee is the reasonable compensation paid by the lawyer to a lawyer by his client for legal services that he has rendered to the latter. The basis of this compensation is the fact of his employment by and his agreement with the client. In its extraordinary concept, an attorney's fees is an indemnity or for damages ordered by the court to be paid by the losing party in litigation. The basis of this is in any of the cases provided which are where an award is made, such as those authorized in the civil code and is payable not only to the lawyer but to the client unless they have agreed that the award shall pertain to the lawyer as additional compensation or part thereof. The power of the court to reduce or even delete the award of attorney's fees cannot be denied. Lawyers are officers of the court, and they participate in the fundamental function of administering justice. When they took their oath, they submitted themselves to the authority of the court and subjected their professional fees to judicial control. Thus, contingent fees agreement violate Article 1491 of the new Civil Code. The answer is provided for in Fabio Antanya versus the Court of Appeals, where it said that the said prohibition applies only if the sale or assignment of the property takes place during the pendency of the litigation involving the client's property. Hence, according to the court, a contract between a lawyer and his client stipulating a contingent fee is not covered by said prohibition under Article 1491, subsection 5 of the Civil Code because the payment of said fee is not made during the pendency of the litigation, but only after judgment has been rendered in the case handled by the lawyer. In fact, under the 1988 Code of Professional Responsibility, a lawyer may have a lien over funds and property of his client and may apply so much as may be necessary to satisfy his local disbursements. What is the effect of a withdrawal of counsel? The attorney who withdraws with good faith is entitled to fees, but the attorney who withdraws without good cause is not entitled to fees. If an attorney is found to have violated the ethical rules, a court may find that any claim to fees from the matter is invalid. Accordingly, an attorney contemplating withdrawal must consider whether it would be or without cause to determine if the client is required to pay fees, because an attorney's lien will always be invalid when the client is not required to pay fees. Whether or not an attorney who stopped providing legal services could recover based on the contingent fee contract prior to full consideration of the contingency. In the case of Ross versus Cannell, a United States case jurisprudence, the court held that under the circumstances of this case, an attorney may not recover on the contract but must seek recovery of fees on the money of quantum meruit. Theory of quantum meruit. That holding does not establish that any attorney who withdraws from the contingent fee representation may always recover fees in quantum meruit. And may I read? It says, rather, it is as opposed to some portion of the contingent contract. The court concluded, if Attorney Ross is entitled to attorney's fees, the measure of those fees is not the contingent fee agreed upon, but the reasonable value of the services rendered. Is the lawyer entitled to a professional fee in a contingent fee arrangement if the client terminates the relationship with or without cause? When the client agrees to pay an attorney's fees, an attorney under a contingent fee arrangement and terminates the attorney before occurrence of the contingency, the attorney may recover based on quantum meruit. In contrast to withdrawal, this rule applies whether the client terminates the relationship with or without cause. However, there are two exceptions to this rule. First, if an attorney violates the Code of Professional Responsibility, then compensation is not available. Second, if the attorney substantially performs the duties owed to the client, then the attorney may recover the full contingency, not just quantum meruit. The substantial performance exception only applies in the rare case where full performance is delinquent by minor and relatively important deviations. Commission referral fees prohibited by openly admitting that he divided the 70,000 pesos to other individuals as commissions referral fees. Respondent violated the Code of Professional Responsibility, which provides that a lawyer shall not divide or stipulates to divide a fee for legal services with persons not licensed to practice law. So we again move on to another aspect, which is conflict of interest or confidentiality. Confidentiality between a lawyer and client. Canon 15 says that a lawyer shall be bound by the rule on privileged communication in respect of matters disclosed by him in to the prospective clients. In the case of confidentiality agreements, you will have noted that the extent of the confidentiality rule, for example, applies not only to matters communicated in confidence by the client, but to all information relating to the representation, whatever source. A lawyer may not disclose such information except as authorized or required by the rules of professional conduct or other rules. The lawyer's duty to keep the confidentialities and effective lawyer-client relationship is largely dependent upon the degree of confidence between the lawyer and the client. The essential factors to establish the existence of attorney-client relationship is where legal advice is sought of any kind from a professional right, and characteristics of the attorney-client privilege would be where legal advice is professionally sought. Number two, the client must intend the above communication to be confidential. Number three, the attorney-client relationship embraces all forms of communication and action. And number four, as a general rule, attorney-client privilege also extends to the attorney's secretary, stenographer, clerk, or agent with reference to any fact required in such capacity. The above duty is perpetual and is absolutely privileged from disclosure. Sorry. As a general rule, the attorney-client privilege also extends to attorney's secretary, stenographer, clerk, or agent with reference to any act required in such capacity. The above duty in the attorney-client relationship is perpetual and is absolutely privileged from disclosure. Confidentiality does not extend to partners and associates. Lawyers in a firm may, in the course of the firm's practice, disclose to each other information relating to the client of the firm unless the client has instructed this particular information to be confined to, for example, the duty of ethical duty of confidentiality. Client identity is privileged in exceptional cases where disclosure would provide the last link in a chain of evidence leading to conclusion that the client committed the crime and would reveal confidential communication between the client and the lawyer himself. Certain instances where a court order is not involved, courts have held the client's whereabouts protected. Lawyers may not be compelled to disclose address of defendant. In child custody cases, for example, when he specifically requested the lawyer not reveal the home address and telephone number of the father and the name of the adversary for that matter, and information that the client requests be kept confidential is protected, and less protection permits a fraud or crime or clearly frustrates the administration of justice. As a rule, lawyers should challenge an order to disclose information about clients. A lawyer who receives a subpoena to testify about the client may file a motion to quash asserting the attorney-client privilege along with any other possible grounds for refusing to comply. A subpoena ducis tecum to a lawyer that makes no attempt whatsoever to confine its scope to relevant non-privileged matter is unenforceable and must be quashed. So that is the last portion on confidentiality between clients and lawyers, and we proceed with grounds for termination for discipline of lawyers. Grounds for disciplinary proceedings against lawyers. Supreme Court is neither bound by the findings of the IBP in cases where, from the Commission on Bar Discipline, you have this recommendation by the Board of Governors of the Integrated Bar of the Philippines for penalties or exoneration after hearing by the bar commissioners. In the case of Dumadag versus Attorney Lumaya, June 29, 2000, respondent must know that the court is neither bound by the findings of the IBP nor much less obliged to accept the same as a matter of course, because as the tribunal which has the final say on the proper sanctions to the respondent and two errant members of the bar, the court has the prerogative of making its own findings and rendering judgment on the basis rather than on that of the IBP. Neither shall the Office of the Solicitor General, which incongruously is still allowed to investigate or to report to the court on erring lawyers, or any other lower court to whom an administrative complaint has been referred to for investigation and report. This becomes a particular irritant between an independent Integrated Bar of the Philippines and the Supreme Court, because in most jurisdictions, almost all jurisdictions outside of the Philippines, the Bar Association is responsible for the discipline within the ranks, and state Supreme Courts or even the federal Supreme Court, for example, in the United States, do not concern themselves with discipline of lawyers, and they do not go to such extent as to interfere in the affairs of the bar associations with reference to the disciplining of its members. But in our case, we have if you go directly and file a complaint in the Supreme Court, the Supreme Court usually assigns the determination of the facts and then the recommended penalty to the Integrated Bar of the Philippines. And the Integrated Bar of the Philippines assigns the factual findings to a bar commissioner, bar discipline commissioner, who reports to the Board of Governors, which latter group will try to determine whether the report or recommendation of the bar commissioner should be affirmed in toto or to modify the same. And the determination of whether a penalty of suspension, reprimand, or any or disbarment may be justifiable, and then this report of the and then this recommendation of the Board of Governors of the Integrated Bar is transmitted to the Supreme Court, including all the records. And it is for the Supreme Court to decide whether, again, to affirm, modify, or deny, or to reverse the recommendation of the Board of Governors of the Integrated Bar. My reference to a smaller turf war is the fact that the independence of the bar here doesn't seem to be illustrative of bar associations or mandatory compulsory bar associations, which should be given full authority actually to discipline its own members within their ranks and peers. Continuous display and use of the title attorney at law after disbarment. This is quite quirky in the sense, because complainant claims that the respondent misrepresented himself as an attorney in the wedding invitation of his son, and a signboard hanging outside the respondent's office displayed the title of attorney at law under the respondent's name. Lastly, in the resolution of the Supreme Court, it says that complainant informs the court that she has been receiving reports that the respondent continues to the practice of law by making other lawyers sign the pleading that he prepares for cases involving his clients. Therefore, on this matter, the resolution of the court is to the effect that the title attorney preceding respondent's name in his son's wedding invitation and the signboard outside his office bearing his name and the words attorney at law are not evidence sufficient to convince the court that respondent continues in the practice of law in violation of the court's decision which ordered the respondent's disbarment. Neither is this court swayed by the complainant's allegation of respondent's continuous practice of law based on mere reports, quote unquote. Without more, these reports, according to the court, are pure hearsay and are without evidentiary value. Nonetheless, respondent, in the case of former lawyer attorney Chua, is hereby ordered to remove the signboard outside his office showing his name and the words attorney at law. What are the guidelines to be observed in the matter of lifting of an order suspending a lawyer from the practice of law? This is a very interesting matter, significant indeed, because there are lawyers which have been suspended by the Supreme Court but continues not to be allowed to practice law even after they have served their sentences because of the bureaucratic wrangle they encounter, not only getting certifications from the different courts of the land, but when they go up to the Supreme Court to have the certification to renew their practice of law. On paper, it says here that after finding that respondent lawyer must be suspended from the practice of law, the court shall render a decision imposing the penalty. Unless the court expressly states that the decision is immediately executory upon receipt thereof, respondent has 15 days within which to file a motion for reconsideration thereof. The denial of said motion shall render the decision final and executory. Upon the expiration of the period of suspension, respondent shall file a sworn statement with the court through the office of the bar confidant, stating that he or she has desisted from the practice of law and has not appeared in any court during the period of his or her suspension. Copies of the sworn statement shall be furnished the local chapter of the integrated bar and the executive judge of the courts where respondent has pending cases handled by him or her, or where he or she has appeared as counsel. The sworn statement shall be considered as part of or proof of respondent's compliance with the order of suspension. Any finding or report to the contrary to these statements made by the lawyer, there will be ground for the imposition of more severe punishment or disbarment as may be warranted. This is the leading case of Maniago. But some lawyers have informed me that somehow they encounter difficulty in resuming automatically the practice of law after their sworn statement, because according to the Supreme Court, they would still need the en banc resolution, which directs them to resume the practice of law even after they have already served their period of suspension. It has happened so many times, several times. I think it is incumbent upon the Supreme Court to make further final clarifications on the matter, because it is grossly unfair to the lawyer has been suspended and service sentence, yet the lawyer continues to be prohibited from practicing his profession just because the Supreme Court has not yet given go ahead, the signal to resume his practice of law. Sometimes it goes beyond the suspension period and even doubles actually the suspension period, especially when you have to get certifications from the different courts of the land that you have not engaged in the practice of law or appeared before their courts during your period of suspension. It's really kind of more than a disadvantage to lawyers, especially if their chief means, primary means of livelihood is the practice of law. Lifting a lawyer's suspension according to Maniago, even in Maniago, is not automatic. The lifting of a lawyer's suspension is not automatic at the end of the period stated. An order from the court lifting the suspension at the end of the period is necessary in order to enable him to resume the practice of the profession. That is what is the beef of some lawyers. If the Supreme Court would mean that they would like to verify and validate, for example, this one statement of the lawyer that he has already served his period of suspension, care might be taken, might be given by the Supreme Court in the sense that it should be like expedient in the sense that that lawyer should be allowed to practice law already, even if it is not according to Maniago, not automatic upon the end of the period stated. But of course, if the lawyer indeed has served the suspension, the Supreme Court is duty bound even to immediately get into the matter and give the lawyer authority to resume his practice, her practice of law after the period of suspension. In administrative cases of against lawyers, the burden of proof rests upon the complainant. Administrative complaints that are prima facie groundless as shown by the pleadings filed by the parties need not be referred to the Integrated Bar of the Philippines for further investigation. They may be summarily dismissed for lack of merit. This is commendable indeed, because most of these cases filed directly with the Supreme Court are usually sent to are referred to the Integrated Bar of the Philippines, where we have a commission on bar discipline. But if it is filed in the Integrated Bar of the Philippines offices, automatically it doesn't go to the Supreme Court, but it goes immediately to fact-finding by the commissioners, and then the report of the Board of Governors still to be submitted to the Supreme Court for final adjudication. The court normally refers administrative cases to the Integrated Bar of the Philippines for investigation report and recommendation. Considering, however, that the question being raised is simple and that no further factual determination is necessary, the court resolves to dispense with such referral and to decide the case on the lack of merit of the complaint. This is, as I said, the bright aspect of Supreme Court, because The consequence is when you have an administrative complaint in the Supreme Court or in the Integrated Bar of the Philippines, any dream of being promoted, of accepting, for example, judgeship or a prosecutorial office, or even appointment to the Court of Appeals or the Supreme Court, becomes a bar for you to apply in the first instance, because you did not get certification from these particular offices. This happened in the case of Senator Laila de Lima. When she was being considered to become a Supreme Court judge, the irony of ironies, she was supposed to be considered by Pinoy, President Pinoy, as member, as associate justice of the Supreme Court. But there were two cases still pending in the Integrated Bar of the Philippines, and apparently certain incidents, circumstances, suspicious in nature, intervened, and the Integrated Bar of the Philippines could not certify that Attorney Laila de Lima had no administrative complaint, and therefore was a member in good standing of the Integrated Bar of the Philippines. This resulted in a very unfair consequence, because she could not be considered by the Judicial and Bar Council precisely because of the pending case in the Integrated Bar of the Philippines. I would have thought that the IBP in that case should have been responsible enough to decide in an expedient manner what to do with the case against Attorney Laila de Lima. Because if she would have been exonerated and recommended and absolved by the Supreme Court likewise, then she could still now be sitting, or I don't know if she has reached the age of 70, she would still be sitting now in the Supreme Court of the Philippines. But as you know, the rest is history. The rules of court on confidentiality of proceedings against, for example, judges of regular and special courts and justices of the Court of Appeal shall be private and confidential, but a copy of the decision of the resolution of the court shall be attached to the record of the respondent in the office of the court administrator. Is there a case where the lawyer will be suspended by the Court of Appeals or the RTC? Rule 139-B, Section 16, and I quote, the Court of Appeals or the Regional Trial Court may suspend an attorney from the practice for any of the causes named in Rule 138, Section 27, gross malpractice, etc., and others, until further action by the Supreme Court of the case. In the same Rule 139-B, Section 17, upon suspension by the Court of Appeals or Regional Trial Court, further proceedings at the court in the Supreme Court will be done upon the transmission of the records of the case to the Supreme Court. Upon receipt of such certified copy and statement, the Supreme Court shall make a full investigation of the case and may reverse, revoke, shorten, or extend the suspension or disbar the lawyer as the facts may warrant. Section 27 is the usual invocation of grounds for the disbarment or suspension of attorneys. And a member of the bar may be disbarred or suspended from his office as attorney by the Supreme Court for, number one, any deceit, malpractice, gross misconduct in such office, grossly immoral conduct, by reason of his conviction of a crime involving moral turpitude, which we have already referred to earlier, violation of the oath which he is required to take before admission to practice, or a willful disobedience appearing as attorney for a party to a case without authority to do so, and the practice of soliciting cases at law for purposes of gain, either personally or through paid agents or brokers, constitutes malpractice. In Attorney Makera, the court said that the disbarment or suspension of a member of the Philippine Bar by a competent court or other disciplinary agency in a foreign jurisdiction where he has been admitted as an attorney is a ground for the disbarment or suspension if the basis of such action includes any of the acts enumerated. The judgment, resolution, order of the foreign country or disciplinary agency shall be prima facie evidence of the ground for disbarment or suspension. Well, this happened in the case of Attorney Leonard de Vera, who was suspended for 2 years, and the basis and main ground for suspension was the fact that there was a disciplinary action meted upon him by the State Bar of California. But people do not know that the action of the State Bar of California was only for a situation where Attorney de Vera opted to surrender his license, but not to be meted out any punishment at all. So after 2 years, he would have wanted to get back his authority to practice and license to practice law in the state of California and the federal courts. But he was already in the Philippines here trying to get recognition for the practice of law. And he was embroiled in an administrative case, and the complainants used that particular case in the United States for disciplinary action, and apparently misguidedly used the same circumstances in the State Bar of California to impose the 2-year suspension upon him. Again, in the case of Attorney de Vera, it was a clear case of being suspended for 2 years. Yet he could get his suspension was kind of extended unnecessarily because he had to get clearances also from the different courts to certify that he did not appear or practice law in those courts during the period of his suspension. It bears stressing here that under Section 2034 of the revised rules of court, the acts which led to a suspension of a lawyer in a foreign country are mere grounds for disbarment or suspension, and that only if the basis of the foreign court's action includes any of the grounds for disbarment or for suspension in this jurisdiction. It is to be applied in comparison with violations of the lawyer's oath in other jurisdictions. What is said here under the rule is that it should also be it should be equally the grounds for suspension, disbarment, or any other applicable disciplinary action against the lawyer. But in the case, for example, of Attorney de Vera, the court said here that judgment or suspension against a Filipino lawyer may transmute into a similar judgment of suspension in the Philippines if the basis of the foreign court's action includes any of the grounds for disbarment or suspension. We likewise held that the judgment of the foreign court merely constitutes prima facie evidence of unethical acts of a lawyer. But that said, what happened was the sorry state of affairs which led to the suspension of Attorney Leonard de Vera. It could have been otherwise were it not for I would know personally some of the other factors behind the scenes which led to his suspension. And we think it was not only tragic, but it was a tragic comedy for that matter. But that said, we have defenses. The judgment of a superior court in another jurisdiction only constitutes prima facie evidence. Due process would demand that he or she be given the opportunity to defend himself and to present testimonial and documentary evidence on the matter in an investigation conducted through the offices of the Supreme Court. It is only after reasonable notice and failure on the part of the respondent to appear during the scheduled investigation that an investigation will be conducted ex parte. Now, again, in the case of Attorney de Vera, he was subjected to an investigation conducted by the Office of the Bar Confidentiality, and later on records will show that indeed the recommendation was for his exoneration. but when it reached the Supreme Court and back, it was overturned, and then he was with a 2-year suspension. Even granting that respondents in the case of Grapilon versus Valdez refers to his accountancy practice, it would not prevent this court from disciplining him as a member of the bar. The rule is settled that a lawyer may be suspended or disbarred for any misconduct, even if it pertains to his private activities, as long as it shows him to be wanting in moral character, honesty, probity, or good demeanor. In this case of Grapilon versus Valdez, respondent is a CPL lawyer who is actively practicing both professions. He is a senior partner of his law and accounting firm, which carries them, and is charged for allowing his accounting firm to represent two creditors of the estate, and at the same time allowing his law firm to represent the estate in the proceedings where these claims are presented. Respondent Valdez here advances the defense that, assuming that there was a conflict of interest, he could not be charged before this court as his alleged misconduct refers only to accounting practice, which led the Supreme Court to rule that the lawyer may be suspended for any misconduct, even if it pertains to his private activities, as long as it shows him to be wanting in moral character, honesty, probity, or good demeanor. In the case of Attorney Balicante, the court holds Attorney Balicante liable because he cannot invoke the separate personality of the corporation to absolve him from exercising those duties over the properties turned over to him by complainant. He blatantly used the corporate veil to defeat his fiduciary interest and conduct and his obligation to the client being the complainant. Toleration of such fraudulent conduct was never the reason for the creation of said corporate fiction. So we segue to the case of judicial clemency and restatement regarding forms of clemency. But this is a very short one. And the basic inquiry, for example, in this case is the instatement of the practice of law which the lawyer has sufficiently rehabilitated himself. And one of the more important considerations here is the fact that indeed, if the lawyer has proven rehabilitation, the applicant must identify the weakness that caused him to engage in a criminal misconduct, and they demonstrate that he has overcome the weakness and must demonstrate that he has accepted the responsibility for the criminal action. And in these cases where lawyers wanted to be reinstated into the practice of law, the usual bone of contention is whether the applicant's conduct raises an issue of fitness to practice law, especially if prior misconduct involves unlawful act, which the lawyer may be obliged to demonstrate rehabilitation. One important factor in determining the rehabilitation fitness of the lawyer is whether the applicant expresses and demonstrates remorse, which again is the mantra given by the critics of Bongbong Marcos on rehabilitation of remorse as a person or the family of the Marcoses. Anyway, we go to now to the last hour. We have expended 2 hours. Our last hour will be on the grounds for canon number 3, which refers to affinity and consanguinity as a basis for disqualification under canon 3. Rule 137 of the revised rules of court refers to the disqualification of judicial officers which is one of those 4 items suggested in the syllabus by the Supreme Court for the bar examinations. And this refers to disqualifications, inhibitions of judges. Section 1 on the disqualification of judges. No judge or judicial officer shall sit in any case in which he or his wife or child is pecuniarily interested as heir, legatee, devisee, or otherwise, in which he is related to either party within the 6th degree of consanguinity or affinity, or if refers to counsel within the 4th degree, computed according to our rules of civil law, or in which he has been executor, administrator, guardian, trustee, or counsel, or in which he has presided in any inferior court when his ruling or decision is the subject of review without the written consent of all parties in interest, signed by them and entered upon the record. A judge may, in the exercise of his sound discretion, disqualify himself from sitting in a case for just or valid reasons other than those mentioned. The objection that judge disqualified and how made an effect. If it is claimed that an official is disqualified from sitting as above provided in section 1, you will find that the party objecting to his competency may in writing file with the official his objection, stating the grounds therefore, and the officials are thereupon proceed with the trial or withdraw therefrom in accordance with its determination of the question of his disqualification. His decision shall be forthwith made in writing and filed with the other papers in the case, but no appeal or stay shall be allowed from or by reason of his decision in favor of his own competency until after the final judgment of the case, referring to motions for inhibitions based on grounds for disqualification. Canon 3 talks about a judge performing official duties honestly and with impartiality and diligence. Remember that we have adopted the new code of conduct for judges and members of the judiciary as a result of the Supreme Court adoption of the universal standards for judges after the Bangalore Agreement. And while these canons in the new code of conduct for judges and judicial officers are not incompatible with the previous code of judicial conduct, according to the Supreme Court, there are gaps or certain aspects which may not be covered by the new code of conduct, then we can refer to the previous code of conduct for judicial officers. But if you read it, upon perusal and careful scrutiny of both the new code of conduct and the previous code of judicial conduct, they're just about the same. And if there are derivatives from the old judicial conduct, these are already embraced in the new code of conduct for judges and the members of the judiciary. And I can see how beautifully crafted the new code of conduct for judicial officer after the Bangalore Agreement. And I would like to think that this has been adopted by almost all democratic institutions involved, where the judiciary embraces the rule of law in as a participant, as a partner in the democratic process in each nation. A judge should not take part in a proceeding where the judge's impartiality might reasonably be questioned. These cases includes, among others, proceedings where, number one, the judge has personal knowledge of disputed evidentiary facts concerning the proceedings. Second, the judge served as executor, administrator, guardian, trustee, or lawyer in the case or matter in controversy, or a former associate of the judge served as counsel during their association, or the judge or lawyer was a material witness thereon. Then you have another prohibition where the judge ruling in a lower court is the subject of review. Another is where the judge is related by consanguinity or affinity to the party litigant within the sixth degree, or with reference to counsel, which we have already stated, the fourth degree, and that the judge knows that the judge's spouse or child has a financial interest as heir, legatee, creditor, fiduciary, or otherwise in the subject matter of the controversy, or in a party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. In every instance, the judge shall indicate the legal reason for inhibition. How do you define affinity? Affinity is defined as the, quote, relation between which one spouse, because of marriage, as blood relatives of the other. The connection existing in the consequence of marriage between each of the married persons and the kindred of the other. The doctrine of affinity grows out of the canonical maxim that marriage makes husband and wife, grow out of the canonical maxim that marriage makes husband and wife one. The husband has the same relation by affinity to his wife's blood relatives as he has by consanguinity, and vice versa. Relationship by affinity refers to a relation by virtue of a legal bond such as marriage. Relatives by affinity, therefore, are those commonly referred to as in-laws or stepfather, stepmother, stepchild, and the like. Affinity in the case of Tigangay versus Judge Wakas denotes the relation that one spouse has blood relatives of the other spouse. It is a relationship by marriage or a familiar relationship resulting from marriage. It is a fictive kinship, a fiction created by law in connection with the institution of marriage and family relation. Article 963 of the new Civil Code talks about proximity of relationship is determined by the number of generations. Each generation forms a degree. Under 964, a series of degrees from 9, which may be either direct or collateral. A direct line is constituted by the series of degrees among descendants and ascendants. A collateral line, on the other hand, is that constituted by the series of degrees among persons who are ascendants and descendants, but who come from a common ancestor. While 965 of the new Civil Code refers to the direct line is either descending or ascending. The direct line unites the head of the family with those who descend from him, and the ascendants binds a person with those from whom he descends. What are the legal theories involved in the prohibitions? The terminated affinity view holds that the relationship by affinity terminates with the dissolution of the marriage, either by death or divorce, which gave rise to the relationship of affinity between the parties. We have a considered view here where the relationship by affinity is simply coextensive and coexistent with the marriage that produced it. Its duration is indispensably and necessarily determined by the marriage that created it, and it exists only for as long as the marriage subsists, such as the death of a spouse ipso facto ends the relationship by affinity of the surviving spouse to the deceased spouse blood relatives. So common law relationships, not a relationship by affinity. The law cannot be stretched to include persons attached by common law relations. Here, there is no blood relationship or legal bond that links the appellant to his victim. Thus, the modifying circumstances of relationship cannot be ordered against him. In one case, the judge is respondent's second cousin by affinity. The former judge's aunt is married to an uncle of the respondent. The relationship notwithstanding, the judge did not inhibit himself from hearing said electoral case. The judge, as alleged, are related within the 6th degree by affinity, that the aunt of the judge is married to the uncle of the respondent. The question is whether or not the judge is related by affinity to the respondent. In this case, considering that the judge is related to his aunt by consanguinity in the 3rd degree, it follows by virtue of the marriage of his aunt to the uncle that the judge is the nephew-in-law of the uncle. Relationship by affinity in the 3rd degree. But the judge is not related by affinity to the blood relatives of the uncle, as they are not his in-laws and thus are not related in any way to the complainant. In like manner, the nephew-in-law of the aunt of the judge is not related by affinity to the blood relatives of the judge's aunt, like the judge himself. In short, the court ruled that there is no relationship by affinity between the judge and the nephew-in-law, as they are not in-laws of each other. The judge is not disqualified under Section 137 to hear the election case. Another case. Complainant contends that respondent judge is guilty of impropriety by refusing to inhibit himself from the case, despite the fact that one of the accused is the father-in-law of respondent judge's daughter. To be sure, respondent judge and accused are not, strictly speaking, relatives within the meaning of 137 of the Rules of Court. Nevertheless, the close personal relationship between them as parents of their respective children, being in our culture known as magbalay, should have cautioned respondent judge to inhibit himself from the case, lest this impartiality be placed in doubt. And not only the impartiality being placed in doubt, but that must have the appearance of impartiality, according to the Code of Judicial, the new code by a respectful observer. Judge's nephew is the husband of the daughter of the counsel for the accused. What happened here? It is alleged that respondent should have inhibited himself from the criminal case because respondent's nephew, Attorney Safra, is married to the daughter of Attorney Casillo, complainant's defense counsel in the case. The complainants here claim that although respondent's relationship is to the husband of the daughter of their counsel, they did not want to respondent to try the case because they wanted to avoid any stigma and or cloud of doubt or any order decision which respondent may render in the case. Well, in this case, the Supreme Court noted that the respondent judge failed to take into account the loss of trust on the part of the complainant as to his impartiality. In In certain cases, when the judge exhibits actions that give rise fairly or unfairly to perceptions of bias, such faith and confidence are eroded, and he has no choice but to inhibit himself voluntarily. A judge may not be legally prohibited from sitting in a litigation, but when circumstances appear that will induce doubt on his honest actuations and probably in favor of either party or incite such state of mind, he should conduct a careful examination. He should exercise his discretion in a way that the people's faith in the courts is not impaired. The better, of course, for the judge is to disqualify himself. Note that the new Code of Judicial Conduct talks about 6 canons. And these 6 canons, as you know, refer to canon number 1 being referring to independence, number 2, integrity, number 3, impartiality, number 4, equality, and number 6, competence and diligence. While when you talk about the lawyer and the lawyer code of professional responsibility, you have 4 categories there. You have the lawyer and the society and the several canons. You have the lawyer and the legal profession, which has several canons. The lawyer and the courts, which has the most numerous of the canons, and the lawyer and the client, where it is delineated about the behavior of a lawyer to his client in cases. In any event, we're referring again to the Code of Conduct of Judges, the grounds relied upon by complainant to support their motion that respondent's nephew is the husband or the daughter of the counsel for the accused, that they lack confidence in respondent's impartiality, has no merit. But while it is not the ground for mandatory disqualification of judges, even if respondent is not even related to the counsel for the accused, at least according to the recommendation of the Supreme Court, the judge should have inhibited himself. When you discuss a pending case with the brother, this was supposed to be one of the more, well, it's not really scandalous, but revealing cases of recent times, relatively recent times, because it's involved the Sabio brothers, where one was the head of the presidential PCGG, while the other was member of the Court of Appeals. And in the letter of Presiding Justice Vasquez Jr. regarding this administrative matter, it points to the fact that by allowing his brother to discuss with him the merit of one party's position, Justice Jose Sabio, this is Justice Sabio, Jose Sabio, gave his brother the opportunity to influence him. Any reasonable person would tend to doubt Justice Sabio's independence and objectivity after such a conversation with the close family member who also happens to hold the high government position, which was chair of the PCGG. As a magistrate, Justice Sabio has the duty to prevent any circumstance that would cast doubt on his ability to decide a case without interference or pressure from litigants, counsels, or the surrogates. I can't forget this because at that time I was slated to be the next speaker after Justice Sabio, and Justice Sabio was the invited speaker of an MCLE program, and he was speaking on legal ethics. To know only during his lecture that he was already being subjected to disciplinary action by the Supreme Court. That was clearly like, well, one of the, I don't know, one of the more quirky situations he was involved in, and I was an observer. Clearly, in this case, respondent judge's participation in the preliminary investigation, the case of Judge Julian, involving his nephew is a violation of the aforesaid rules laid down to guide members of the judiciary. The rationale for the rule on disqualification of judges stems from the principle that no judge should preside in a case in which he is not wholly free, is not wholly disinterested, impartial, and independent. The rule which says that the judge should not handle a case in which he might be perceived to be susceptible to bias and partiality is undoubtedly an age-old tradition rule, and it is to preserve the people's faith and confidence in the Court of Justice and the perception by the public that indeed the courts of justice are impartial and possess necessary integrity to implement and pursue the process of grinding the wheels of justice. A judge should have immediately inhibited himself from hearing the case, learning of the entry of appearance of his son's law firm. The incorporators, for example, in this case, Mindanao Institute versus the United Church of Christ. This also, by the way, applies in arbitration cases where these canons about judges also apply to arbitrators or members of the tribunal or who are also sole arbitrators. A stepdaughter, by the way, has no common ancestry by her stepmother. The next subject here is extrajudicial activities, where we find that certain activities of the judges are contained or embraced within the canons of judicial ethics and the Code of Judicial Conduct is a supplement to the new code. What we said earlier is because of the embrace by the Supreme Court of the canons of judicial ethics, the new Code of Judicial Conduct, the canons of judicial ethics and the Code of Judicial Conduct becomes a supplement to the new diktat of the new code. The canons of judicial ethics and the Code of Conduct were promulgated on September 1989 and took effect on October 1989. The new Code of Judicial Conduct of the Philippine Judiciary shall take effect and took effect on June 2004. The code, which shall be referred as the new Code of Conduct, supersedes the canons of judicial conduct and ethics. And from June 2004, the provisions or concepts are embodied in the code. And provided, however, as we said again earlier, in case of deficiency or absence of specific provisions in this new code, the canons of judicial ethics and the Code of Judicial Conduct shall be applicable in a suppletory character. We have already said that in Canon 4, you have very importantly propriety. Propriety and the appearance of propriety are essential to the performance of the activities of a judge. The judges shall avoid impropriety and the appearance of impropriety in all their activities, and it's a subject of constant public scrutiny. Judges must accept personal restrictions that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly. And in particular, judges shall conduct themselves in a way that is consistent with the dignity of the judicial office. Quite a burden, of course. But once you accept the office of being a judge or member of the judiciary, you are supposed to be confined within these four corners of the Code of Judicial Conduct. Sections 3, 4, and 5 talks about judges and their personal relations with individual members of the legal profession who practice regularly in their court should avoid situations which might reasonably give rise to the suspicion or appearance of favoritism or penalty. Judges shall not participate in the determination of the case in which any member of her or his family, if their family represents a litigant or is associated in any manner with any case. Judges shall also not allow the use of their residence by a member of the legal profession to receive clients of the latter or other members of the legal profession. Judges shall not use or lend the prestige of the judicial office to advance their private interests or those of a member of their family or anyone else, nor shall they convey or permit others to convey the impression that anyone is in a special position improperly to influence them in the performance of their judicial duties. Among others, the judges should inform themselves of their personal fiduciary financial interests and shall make reasonable efforts to be informed about their financial interests of the members of the family. They are entitled, however, to freedom of expression, belief, association, or assembly. But in exercising such right, they shall always conduct themselves in such a manner as to preserve the dignity of the judicial office and the impartiality of the independence of the judiciary. Subject to the proper performance of judicial duties, here it might be debatable when you say that the judges may write, lecture, teach, and participate in activities concerning the law, the legal system, the administration of justice, or related matters, while the old Code of Judicial Conduct did not allow them to participate, write, lecture, or teach in concerning the law or legal system. But I guess this new code, signifies the better appreciation of that canon, because who else but justices, judges, or members of the judiciary could be more qualified to talk about the law, to teach, participate, or lecture on the legal system, administration of justice, and related matters for that matter. So my take is that they should not be prohibited from, lecturing, teaching, writing, participating in activities concerning the law, the legal system, and administration of justice. The judges also may appear at a public hearing before an official body concerned with matters which particularly refers to the law, the legal system, the administration of justice, and related matters. And they can engage in such activities that do not detract from the dignity of the judicial office or otherwise interfere with the performance of their official functions. There was a joke going around then that, you can engage in golfing activities with prominent lawyers, so private practitioners, but precisely the impression being given to the public would be different if they are not careful enough to avoid just even a perception of partiality or bias or camaraderie with private practitioners. The judges shall not knowingly permit their court staff or others subject to their influence, discretion, or authority to ask for, accept any gift, bequest, loan, or favor in relation to anything done to be done or omitted to be done in connection with their duties or functions. There is an interesting section here, section 12, which says that judges may form or join associations of judges or participate in other organizations representing the interests of judges. And why not? Even if it may involve not only specifically, exclusively Judges Association, I would like to think likewise that if it will not unduly prejudice their integrity, partiality, or bias, nothing for example, would prevent the judge from being a member of the Rotary Club, member of other civic associations, which associations are organized precisely for the benefit of humankind. Judges may receive a token, gift, award, or benefit as appropriate to the occasion on which it is made, provided that such gift, award, or benefit might not reasonably be perceived as intending to influence the judge in the performance of judicial duties or otherwise give rise to the appearance of partiality. This particular Rule 138 of the revised rules of court, where certain attorneys are not allowed to practice, includes that no judge or any other official employee of the Superior Courts or the Office of the Solicitor General shall engage in private practice as a member of the bar or give professional advice to clients. I think you will take this as humorously with a grain of salt, because we know for a fact that this is sometimes violated, even if rarely. The judge shall not engage in the private practice of law unless prohibited by the court. Judge may engage in other professions provided that such practice will not conflict or lend to conflict with his judicial function. Why are you prohibited to teach violin or the saxophone to others if you want to share your talent or expertise with other persons, even if you are a judge? Instances where you talk about the judge's family. The judge's family includes spouse, son, daughter, son-in-law, daughter-in-law, any other relative by consanguinity or affinity within the 6th civil degree, and a person who is a companion or employee of the judge and who lives in the judge's household. To escape, according to the court, our disciplining wrath, respondent judge argues that the resolution he issued was a mere expression of his legal opinion and not a judgment or order which adjudicates and settles rights and obligations of the parties. He said that the petition for declaratory relief earlier quoted is not a pleading but a mere letter request for a legal opinion. Hence, complainant Gozon here was not entitled to notice and hearing. This is the case of Gozon versus Judge Liango. Court said that even assuming arguendo that the resolution was a mere legal opinion, still respondent must know that rendering of legal opinions is not the function of a judge. The function of the court is limited to adjudication of actual controversies involving rights which are legally demandable or enforceable. Unlike lawyers, judges cannot render legal advice. Judges are expressly prohibited from engaging in the private practice of law or from giving professional advice to clients. The question is, a judge who violates the judicial code of conduct, does he also violates the lawyer's oath? In the same case, immediately adverted to, the court, if I may read, quote, "We ruled that because membership in the bar is an integral qualification for membership in the bench, the moral fitness of a judge also reflects the latter's moral fitness as a lawyer. A judge who disobeys the basic rules of judicial conduct also violates the lawyer's oath." As attorney, in fact, he cannot do so also in litigation. The prohibition applies equally to the appointment or acceptance by judges to the post of attorney, in fact, in actual litigations, a fact which is also by and large incompatible with the high office, functions, prestige, and privileges of a judge. It is even of no moment, although worse, that the case where he accepts such designation as attorney, in fact, is one that pens before his own court. I don't know how stupid this judge would be. But in any case, you have these prohibitions on teaching hours of judges, justices, and personnel of the judiciary, because you have to apply for to the Supreme Court for the certification, and the number of cases which you have as a judge will still be disposed of within a particular period of time. The failure to secure permit to teach, for example, of judges, well, the respondent's judge's failure to accomplish the request for permission to teach is a clear violation of the judiciary rules and regulations, indicating respondent judge disregard of the authority of the Supreme Court. For no matter how insignificant or inconsequential the circular may seem to respondent judge, he should have complied with it. It is not necessary to the proper performance of the judicial duty that judges should live in total seclusion or retirement, or live the life of a hermit. It is desirable, however, so far as the reasonable attention to the completion of their work will permit, that they continue to mingle in social intercourse, and that they should not discontinue their interest in their appearance at meetings of members of the bar. The judge should, however, in pending or prospective litigation before him, be scrupulously careful to avoid such action as may reasonably tend to weaken the suspicion of persons that the social or business relations or friendships constitute an element in determining his judicial course. What about political activities of judges? What is allowed is that the judge is entitled to entertain personal views on political questions. What is prohibited is in order to avoid suspicion of political partisanship, the judge should not make political speeches. A judge should not even contribute to party funds, and a judge shall not publicly endorse candidates for political office or participate in other partisan political activities. It is also improper, of course, under the civil service law, to engage in partisan political activities. In the case of Bistan versus Judge Nicolas, the court said that for having held himself out as a congressional candidate while still a member of the bench, respondent took advantage of this position to boost his candidacy, demeaned the stature of his office, and must be pronounced as guilty of gross misconduct. The judge cannot be appointed to executive positions in any enterprise in violation of Supreme Court circulars not to accept the position of director of any other position in any enterprise, and must resign immediately if he has to accept that. Judge Estrada, in the one case, who was appointed to the judiciary, did not resign from the board of directors of the Rural and Labrador. Therefore, he was subject to disciplinary action after he did not inhibit himself from a particular case before him. The act of writing a letter to opposing counsel and defending a right amounts to private practice of law. And the case of Carwal versus Cruzola talks about the tenor of the letter of the judge as representative of Antespo was defending the latter's rights over the disputed property. Respondent's act of representing and defending the interests of a private individual in the disputed property constitutes private practice of law. It has been ruled that the practice of law is not limited to the conduct of cases in court or participation in court proceedings, but also includes preparation or pleadings or papers in anticipation of litigation, giving advice to clients or persons needing the same. There are myriad other circulars of the Supreme Court or other prohibitions against judges. Time constraints cannot allow us to do so and complete this particular presentation. So, as prescribed by Justice Leonin's recommendation, we now go to direct and indirect contempt as part and parcel of the syllabus on legal ethics. Try to access my notes on this here. This discussion on contempt of court concept of clauses is a result of the former Chief Justice Persamin's comments in the case of Lorenzo Shipping Corp.